Dr. Miller, do you still have those transcripts before you?
Yes, I do.
I'd like to direct your attention to State's Exhibit 897. That would be the transcript that goes along with session number 27. And if you would look, sir, on page 2, line 61.
Yes.
The defendant made reference to the Woodbridge Police Department being the closest one to Staten Island.
Yes.
Sir, who do you know that lives in Staten Island or that area that's a reference to?
I believe it would be Celine and Alex.
Now, sir, you've told this jury, you've described meeting with law enforcement several times. You described testifying in the grand jury. And you've described that they've asked you a lot of questions, correct?
That's correct.
Sir, did you have anything to do with the murder of Bill McGuire?
Absolutely not.
Did you have anything to do with cutting up his remains?
No, I did not.
Did you have anything to do with transporting them to the area of the Chesapeake Bay Bridge?
No, I did not.
And in all the time that you've spoken to this defendant, did she ever tell you that she did?
No, she did not.
Now, sir, I'd like to direct your attention again back to RMA. When you were working there and the defendant was working there as a nurse. At that time, sir, were there ever occasions where you were prescribing something to a patient where the defendant filled out the prescription for you?
Sure.
And, sir, did the defendant ever sign your name to a prescription?
Yes.
And, sir, did the defendant have access to RMA prescription pads?
Typically, the nurses had all the prescription pads. I don't know of any physician that had them, close by.
And back in 2004, that was an accepted practice there, correct?
That or a nurse would hand us blank scripts and have them sign them, and then they would fill them out for various fertility medications.
But you do know, sir, that the defendant has signed your name to prescriptions?
Yes.
Now, sir, can you describe to the jury, were there ever occasions where you prescribed something to the defendant?
Yes, there were.
And can you describe those occasions, sir?
Well, if there was a urinary tract infection or other type of female infections, cold, sinus infection, those sorts of things.
So if she was stuck and needed an antibiotic or something, you would
Yes.
give it to her?
Yeah.
And this morning you described that you prescribed Xanax.
Yes, I did.
And, sir, again, just for reference as we enter this topic, that was after her husband had disappeared, according
Yes.
to her, right?
Morning the 29th.
Sir, I'd like to direct your attention specifically to April 26th. Did you prescribe Xanax to her on that day?
No, I did not.
Mr. Precioso, can we have a year?
Oh, 2004, Judge. I apologize. One moment, Judge. Oh, I got it. Sorry. Your Honor, I'm showing the witness State's Exhibit 1125, which is a 3-page document. Dr. Miller, can you take a look at that? Have you examined that exhibit before today, sir?
Yes, I have.
And I'm correct that that exhibit is a composite of records, correct?
That's correct.
And, sir, in that exhibit, it lists several different medications for the defendant that were put in under your name, correct?
That's correct.
And, sir, I would like specifically to call your attention to item number 37 on the list, a prescription for Xanax that was filled by the defendant under your name, sir. Are you certain you didn't prescribe that?
Yes, I am.
And, sir, on that list, are there certain medications that you did prescribe?
Yes, there are.
Are there others that you didn't?
Yes, there are.
And the ones that you didn't, sir, can you read those out loud?
Prescriptions for Xanax on the 2nd of May, another one on the 12th of May, and one on the 31st of May.
And what were the dosages of the Xanax on those dates, sir?
The very first one on the 2nd was 0.25, and on the 12th and the 31st was 0.5 milligrams.
And 0.5 milligrams is more than the 0.25 milligrams?
It would be double, yes.
And, sir, those 3 prescriptions for Xanax that you just mentioned, the 26th, May 2nd, and the last one was on what date, sir?
31st.
Those were not prescribed by you?
No.
And how many pills were prescribed in each, does it say?
I don't see where it says the dispense, or how many were dispensed.
Your Honor, I'm showing the witness State's Exhibit 1118, which is a record from Caremark. And I'm directing the witness's attention to page 4 of the document, which is Bate stamp 03802, and specifically to those that correspond with the date, and where it says days supply in the second column. And Dr. Miller, would you please go to the April 26th entry
Yes,
for, is it aprozolam?
that's why I say Xanax.
Okay. Xanax would be the
Yeah,
name for the generic drug, alprazolam.
No, Xanax would be the trade name.
And do you know how to say the word, sir?
Alprazolam?
Alprazolam. Thank you. On the 26th, how many days supply was it?
6-day supply and quantity was 20.
And unit quantity would be 20 pills, sir?
That's correct.
And on May 2nd, 2004?
10-day supply and 30 were dispensed.
And that was of the 0.25 milligram tablet, correct?
That's correct.
And then on the 12th?
12th, again, a 10-day supply, 30 were dispensed, and that was 0.5 milligrams.
And on the 31st?
31st was 30-day supply, and 90 were dispensed, and it was 0.5 milligrams.
And 90 pills were dispensed.
Correct.
Now, sir, you did say that you did call in a prescription for the defendant on the 29th, correct?
Yes, I did,
And what was that prescription for?
for Xanax.
And do you recall the dosage that you called in?
I believe it was 0.25, and I believe the pharmacy was Walgreens.
And do you remember how many pills you prescribed, sir?
Not exactly, but I would say probably around 10 to 20.
And you did that because she seemed to have an immediate need at that time?
Correct. I was going to call it in, and she was going to pick them up that morning.
Now, sir, I'd like to show you a prescription, and I'm going to ask you not to include what the medication is. It's State's Exhibit 302. Sir, again, please don't say what the medication is for. Could you tell the jury, please, what State's Exhibit 302 is?
It's a prescription written out with my name checked off, written to Melanie McGuire, dated January 15th, 2004.
Now, is that your signature at the bottom?
No, it's not.
Do you recognize the handwriting of the prescription?
It appears to be Melanie's.
And you're familiar with the defendant's handwriting?
To some extent, yeah.
And the signature, your signature at the bottom,
Mhm.
who signed that, sir?
It's probably Melanie's signature.
But you don't know for certain?
No, I don't know for certain.
Is that your signature?
No, it's not my signature.
Your Honor, the state would, subject to redaction, I'm not going to publish it today, but subject to redaction, the state would move this exhibit into evidence.
No objection, Your Honor.
It's S-302.
S-302, and it won't be published to the jury today, sir.
All right, S-302 will be admitted into evidence without objection.
The record should reflect that I'm handing the witness State's Exhibit 239, which is a prescription, it's already in evidence. It's a prescription in the name of Ruth McGuire. Sir, do you recognize that?
Do I recognize the prescription pad?
All right, let's start with the prescription pad. Do you recognize the prescription pad?
Yes, it's a prescription pad from RMA.
And who's the doctor that's checked off?
It's my name that's been checked off.
And the signature across the bottom is purported to be whose, sir?
I believe it's purported to be mine.
Is that your signature, sir?
No, it's not.
Sir, did you ever have a patient that you know of named Ruth McGuire?
No, I have not.
And that's a prescription for flurazepam, correct?
Correct.
And, sir, is flurazepam something that you prescribe to your patients?
No, it's not.
Sir, did you write that prescription?
No, I did not.
And is that signature at the bottom yours?
No, it's not.
I just put down the envelope. 239, I believe. Lastly, sir, I'm handing you State's Exhibit 222. It's already in evidence. It's a prescription in the name of Tiffany Bain. Do you recognize that prescription pad, sir?
Yes, I do.
And where is that a prescription pad from?
It's from RMA, and it has my name checked off.
And who's the purported signatory at the bottom?
It's purported to be myself.
And sir, is that your signature?
No, it's not.
Now, sir, do you recognize the name Tiffany Bain to be someone that you've treated?
Yes, she was a patient of mine.
Sir, that's a prescription for chloral hydrate, correct?
That is correct.
Have you ever prescribed chloral hydrate to a patient?
No, I have not.
Did you prescribe chloral hydrate to Tiffany Bain?
No, I did not.
Sir, did you write that prescription?
No, I did not.
Now, sir, I'm handing you, again, State's Exhibit 239. Sir, if you know, are you familiar with the handwriting on those two prescriptions?
Yes.
And whose handwriting do you believe it to be?
Appears to be Melanie's.
Sir, I'd like to call your attention now, Dr. Miller, to the middle of August in 2005. Were you still working at RMA at that time, sir?
Yes, I was.
And did there come a time when you received something in the mail at your office?
Yes, I received a letter that was addressed to Peter Harvey.
Well, you mean the greeting of the letter was addressed to your Peter
No, the
Harvey?
actual envelope had my name on it and had marked personal at the bottom.
And inside that envelope was what, sir?
It had a letter that was addressed to the Attorney General at the time, Mr. Peter Harvey.
And did it have anything else besides the 4-page letter?
Yeah, there was a separate small cut piece of paper that was addressed specifically to me.
Sir, I'm going to hand you State's Exhibit 1128 for identification. Now, this is a Xerox copy. Could you look at the Xerox copy and tell the court what that's a Xerox copy of?
It's a Xerox copy of an envelope and has my name on the front with the address in Morristown.
And if you would page through, the first page is the envelope. What else is in there?
The next item is the letter that was directed towards Mr. Harvey.
And sir, that's a 4-page typewritten, single-spaced
That's correct.
letter. And the last page of that exhibit, sir?
Then that was the part that was directed towards me.
And sir, is that an exact Xerox copy of the envelope, the 4-page letter to Peter Harvey, and the note
Yes.
to you, sir?
Yes, it is.
And does that Xerox copy fairly and accurately reflect the contents of the letter that you received in mid-August at your office in
Yes, it does.
Morristown? One moment, please, Judge. And, Your Honor, the letter has been, the state would submit, the letter has now been authenticated. I've conferred with Mr. Tapapina. I would like just at this time, Judge, to move into evidence just the portion of the note to Dr. Miller.
You have the same exhibit number for the letter and the note?
Yes.
Or you just want to move the note in?
At this time, I just want to move the note in. We'll be moving the letter in later in the case,
And
Judge.
there's no objection to a copy being admitted?
No, Your Honor.
All right, then, that portion of S-1128, the note to Dr. Miller, will be admitted into evidence without objection.
And Dr. Miller, directing your attention just to the note, sir. Would you read the note out loud to the jury?
You either got railroaded the same as she did, or you're a cowardly bastard who made up lies to save himself. Either way, help her, you dumb son of a bitch.
And, sir, RMA of New Jersey has had offices in 2005 in how many separate locations?
There were 4 locations.
And the main office is Morristown, correct?
That's correct.
And where was that addressed to?
To Morristown.
And that's where you received it, correct, sir?
That's correct.
And after you received it, what did you do with it?
I tried calling the prosecutor's office, could not get through to anybody, and then I called my lawyer, Mike Rogers, and he sent one of his people over to pick it up and deliver it as state's evidence.
And, sir, only if you're aware, were you aware that it was received by other persons or media outlets as well?
At that time, I wasn't aware, but soon it came out in the papers that the Attorney General got the letter and a couple of newspapers.
And, sir, the letter was anonymously written, correct?
Yes.
No further questions at this time, Judge.
Good afternoon, Doctor.
Good afternoon.
Sir, I just want to clear up a few things from your direct first and foremost. That letter that you said, and we'll get to that in a little bit, was sent to Morristown, the Morristown office?
That's correct.
But you were only at Morristown 1 day a week, right?
On most occasions, sometimes I would come up there more frequently to cover for a procedure or two.
But on most occasions, you were in Somerset, right?
That's correct.
All right. And certainly, Melanie McGuire knew that you were in Somerset, correct? Most of the
Yes,
time?
yes, she did.
And not Morristown, right?
That's correct.
Sir, I'm going to show you a copy of...
It's collectively.
I'm going to show you the State Exhibit 1128, I think 28 again, sir. Just take a look at this right here.
Okay.
That's the envelope that came in, sir?
Yes, yes, it is.
Okay. And you don't recognize that to be Melanie McGuire's handwriting, do you?
I do not, no.
Sir?
I do not.
Okay. One other thing I want to clear up before we get into some of your earlier testimony is, when you were talking about the pills that you received or that you heard about that were found in the Woodbridge apartment by Celine, Melanie's friend, you said they were found in a valet, correct? That's what you heard.
Wasn't there, but that's what I understood, yes.
Okay, and you described the valet as like a place where you would keep your jewelry, right?
I believe so.
Okay. But you weren't trying to give this jury the impression that those pills were found with jewelry, were you?
No.
Okay.
Absolutely not.
You were talking about a valet where jewelry would be kept?
Yes, sir.
Okay. It's not your understanding that any ring was found or anything like that?
Absolutely not.
Okay. Now, Melanie McGuire never complained to you, sir, that her husband ever beat her, did she?
I've not heard her ever say anything about physical abuse, no.
Melanie McGuire never asked you for any money, did she, sir?
No, she is not.
Melanie McGuire never asked you to leave your wife, sir?
She did not, no.
And Melanie McGuire never appeared to be jealous of your wife, correct?
No, she wasn't.
Now, you gave a series of statements, I think you said on your direct, 3 grand jury appearances? Yes, sir?
Yes, sir.
You gotta audibilize your responses. All in 2005?
I believe so.
Right. And you had 3 in-person meetings in 2005 at least, correct?
Yes.
Okay. And you've had sessions to prepare for your testimony here today?
Yes, I did.
Okay. You created 2 consensual phone recordings?
Yes, I did.
Working with the police?
Yes, I did.
And you did a phone interview with Virginia Beach Police Department in 2004?
Yes, I did, sir.
Okay. And you understood when you went to the grand jury each and every time the importance of that, right, sir?
Yes, sir.
Okay. And you understood that it was important in the grand jury to be honest?
Yes, sir.
As a matter of fact, you appreciated the fact that if you lied in the grand jury, that's a crime?
Yes, sir.
And you understood that you had to be complete in the grand jury, not leave anything out, right?
Yes, sir.
And you were, right?
To the best of my ability, yes.
You didn't attempt to embellish or anything, did you, sir?
No, I did not.
And your grand jury testimony in 2005, sir, was a lot closer in time to the conversations you were relaying to this jury than today, obviously, right?
Yes, sir.
Almost 2 years earlier, correct?
Correct.
And in 2005, you were relaying to that grand jury under oath the same conversations that you had with Melanie in 2004 and 2005, right?
Yes, sir.
And conversations in regards to this investigation, correct?
Yes, sir.
And your memory certainly did not get better 2 years later, did it, sir?
No.
As a matter of fact, it's fair to say, I think human nature dictates that your memory over time will evaporate, correct?
Correct.
So you'd agree that your testimony in May of 2005 in regards to conversations would tend to be more accurate than it would 2 years later, correct?
Yes.
Okay. Because in 2005, when you testified in the grand jury, sir, and we'll go through some of it, you never told the grand jury about any future plans that were put in place with Melanie McGuire, did you?
I did not.
And when you testified in 2005 in the grand jury, you never told them that the day she went to the closing, she was surprised on that day, did you?
Objection. Form.
Did you understand that question, sir? Doctor?
Can you repeat it?
Sure.
Please.
You never told the grand jury in 2005 that the day Melanie McGuire went to the closing, the day of the closing, that she walked into the closing and appeared surprised that was a closing. Did you say that to the grand jury?
Objection. Your Honor, I would ask if Mr. Tacopina could show the witness where his attention was directed to that fact and what he answered, and if that diverges from what he's saying now.
Yeah, I will do that, Your Honor. I'm just asking the witness if you recall saying.
All right, go ahead.
I do not recall saying that,
Okay.
no, sir.
But you did tell the jury today, for instance, that she called you from the closing, the day of the closing, and didn't realize a closing was going to occur.
She said that she was going to meet at the lawyer's office, and she said, yes, she was surprised that the other attorney was there and that the actual closing was going to occur at that point.
Okay. And Ms. Presley also gave me a good suggestion. We'll go to your grand jury in a second, just to see what you said on that, okay? You also didn't tell the grand jury, sir, in 2005, that Melanie was upset about the closing, did you?
If it's not in the grand jury testimony, then I did not.
Okay, well, I'll read it to you, okay, sir? And lastly, by the way, did you tell the grand jury in 2005, 2 years ago almost, that you recall the nature of your conversation with Melanie McGuire on April 28th at night, that 15-minute phone conversation that you told this jury some details about her being upset and whatnot? Did you recall that in 2005?
Did I recall it in 2005?
Yes, sir.
Yes.
You did? Okay. Let's start with that then, okay? Question in the grand jury, May 17th, 2005. This was under oath, right, Doctor?
Yes, sir.
Okay. Page 85, line 13. Question to you, sir, by the prosecutor. Later that evening, around 8:12, do you recall receiving a phone call from Mrs. McGuire? Answer in the form of a question. To my T-Mobile again? Question, yes. Answer, it is possible. I don't recall the conversation. Question, do you recall calling her at 8:26 and talking for 15 minutes? Answer, now, by the way, that's the same call you were asked about this morning by Ms. Prezioso, right? Yes, sir?
Yes, sir.
Okay. And you told this jury that you recalled the substance of that conversation and Melanie was upset, right?
Yes, sir.
Okay. Let's hear your answer in May of 2005. Okay, doctor? Read the question again. Do you recall calling her at 8:26 and talking for 15 minutes? Answer, it's certainly possible, yes. Again, this would have been our typical evening phone call saying how the kids were doing and wishing each other good night. Question, you don't specifically have a memory as you sit there today of talking to Ms. McGuire between 8 and 9 o'clock the night of the 28th? Answer, I don't remember the particular conversation. No. Well, that's different than what you told the jury today, isn't it?
Sounds different, yes, sir.
And before we started doing this, you agreed with me that your memory in 2005 was certainly more reliable than your memory is today. You
Yes.
said that right, sir?
Yes, sir.
Okay. Now, you then are asked about the closing in the grand jury, and I asked you about whether Melanie was upset or concerned before the closing. Question to Dr. Miller. Same grand jury. Going back to the closing, but before William was missing, do you recall Mrs. McGuire being upset or concerned or giving you any news about anything? Answer, no, she wasn't upset or concerned. You recall giving that answer to the grand jury in May of 2005, sir?
Yes, sir.
Okay. And you were then asked about that call at 4:59 a.m. on the morning of the 29th? You recall
Yes, sir.
that? Ms. Prezioso asked you that today, sir? Did you tell the jury you recalled making that call?
Do I recall actually making the call?
Yes, sir.
No, I don't.
As you sit here today, you don't recall making that call?
No.
And you certainly didn't remember making the call in 2005, did you?
Just by the phone records.
Just by the phone record?
Yes,
So
sir.
you were reading off a piece of paper, not based on your recollection.
That's correct,
Which
sir.
is fair, but, by the way, we'll get to that call a little bit later, but that was not a usual time for you to call Ms. McGuire at 4:59 a.m., was it?
On occasions, I would call that early, yes.
Really?
Mhm.
And where did you expect to find her at 4:59 a.m.?
I never expected to find her. I always expected to go to voicemail.
That was on the private phones that you had?
Yes.
Okay. And you certainly don't remember, if you don't remember making the call, you don't remember any conversation or a message you left, right?
Typically, if I called that early, it would just to say, hello, how are you doing? I love you, and that would be it.
Did you get a chance to review your phone records before you testified here today, sir?
Yes.
Okay. We'll get to 4:29 a little bit later, but did you see any other phone call at 4:59 a.m. in those phone records, sir?
I think there were a couple others, yes.
Okay. Well, you'll point them out when we go there a little bit later, okay? Now, I asked you whether or not you recall that Melanie was surprised the day of the closing. Right, Dr. Miller?
Yes.
Now, you told this jury that the day of the closing, according to your conversations with Ms. McGuire, the day of the closing, she walked into that lawyer's office and didn't know she was there for a closing, correct?
Correct.
I'm going to read you the questions you asked in the grand jury about that, okay, sir? And your answers. May 17, 2005, page 72. Question by the prosecutor. Mr. and Mrs. McGuire took that day off from work to close on it, right? Close on the house. Answer right. So right away, you recall now that Melanie took that day off to close on the house?
That's correct, yes.
Okay. So if she took the day off in advance to close on the house, she knew about the closing, right?
Well, her impression to me was that the closing wasn't going to happen.
Okay, let's see what else you said. Question, they had an appointment with the attorney, right? Answer, yes. Question, there were lots of phone calls before then to banks and mortgage companies, everything else, to get set for that day, right? Answer, yes. As a matter of fact, they were planning, or William was planning, for the McGuires to be moving from the apartment in Woodbridge to this new house in Warren County that weekend, right? Answer, I believe they had scheduled Friday for the move. The question by the prosecutor. So why, Dr. Miller, was she surprised about the closing? You recall what your answer was?
No, I don't.
Okay. I don't think she was surprised, just very nervous. She's not sure if they could actually afford the mortgage when she signed the papers and saw the fee on the mortgage, on the paper that they were doing the right thing. You recall giving that answer to that question, sir?
Yes.
Okay. There you say you don't think she was surprised, correct?
Yes, sir.
Okay. And again, I don't mean to keep reiterating this, but we're going to rely on your 2005 under oath testimony over
sir.
today's, correct? Your memory.
That's what I said, yes, sir.
Okay. Now, she was nervous, certainly, about the financial burdens that were associated with that closing, correct, sir?
I believe so, yes,
Okay.
sir.
And this is based on what she told you, correct?
Yes, sir.
Now, she was not resentful of her husband at that time at all, was she?
She was resentful to
Yeah.
her husband?
Did she sound resentful to you of Mr. McGuire because of the closing?
Couldn't answer that question.
Well, let's see if you were able to in the grand jury in 2005. Question on page 19 by the prosecutor. Was she sounding resentful of Mr. McGuire at this time? Answer, I did not pick that up in her tone, no. Question by the prosecutor, she wasn't upset with her husband? Answer by you, no, she wasn't upset with her husband at that time, no. You recall giving those answers to
Yes,
those
sir.
questions in the grand jury, doctor?
Yes, sir.
And Doctor, you asked some questions about whether Melanie was excited, if you will, or eager to make the move into the new house. Remember that this morning, sir?
Yes, sir.
Okay. And the answer, the real answer is, there were concerns, obviously, about the financial burdens, correct? But she was excited for her kids and the family, correct?
Yes, sir.
Okay, so it was bittersweet, you would say.
Yes, sir.
So it wasn't as if she didn't want anything to do with the house, was it, sir?
That's correct.
Okay. And before that closing, before the time frame before that closing in April of '04, you had made it clear to Melanie that you were not planning on leaving your wife anytime soon, correct?
That's correct, sir.
Okay. Not anywhere in the immediate future, correct?
That's correct.
And we'll get there. And one of the reasons for that, Dr. Miller, I think the primary reason you told the grand jury was that you wanted to be there with your children every day, right?
That was part of the reason. Yes, sir.
And you didn't want to lose being their father every night, right?
That's correct.
Both, Doctor, both Melanie and yourself had decided in April of 2004, at least leading up to April of 2004, that neither of you were going to leave their spouses because of the kids' sake, correct?
Not at that time, no, sir.
Right. And you viewed your relationship with Melanie as long-term, right?
Yes, sir, we did.
But you never had, up in April 2004, you hadn't made a definitive plan. Look, in 5 years, we'll both divorce, we'll meet in this house, we'll have a new family. You didn't have those sorts of plans, did you, sir?
I think they were in our minds, but no, nothing was like written down in a time frame of 2 years, 3 years, nothing like that.
Okay, well, you say you think they were in our mind. I mean, that's what you were thinking, right?
Yes.
You didn't verbalize that with Melanie, did you?
Yes, we both talked about it.
About making a definitive plan, sir?
Yes.
Okay. So did you, here's my question. Did you or did you not, in April of 2004, have plans in place to create a future together where you were going to live together?
At that point, no, sir.
Okay, at that point, no, sir, right?
That's correct.
Okay. So after April of 2004, when did those plans come into being?
The plans have always been long-term that we were going to end up being together. I don't think we ever had a specific date in mind or year in mind that was going to happen.
As a matter of fact, you were asked about that in the grand jury, right?
Yes, sir.
Okay. You were asked on page 15 of 5-3, May 3rd, 2005. Question. You said immediate future. Did you ever have long-term plans about being together? Answer by you. Well, we didn't have any plans in place at the time. I think we were just living things day by day, right? That's what you were doing.
Yes, sir.
I mean, you were together. You were having an extramarital secret affair,
Yes, sir.
as you thought. And there were no plans in place to have a date certain where you were going to get together, right?
There was no date certain, but I think we were both committed in our hearts that we wanted to be together.
In your heart, you were committed that you wanted to be together? And of course, that would take two to be together,
Yes, sir.
correct? Sir?
Yes.
Now, one of the reasons she did not want to get a divorce was because she did not want her children to not have their father around on a daily basis, correct?
You're talking about Melanie?
Yes.
No, I was not aware of that.
Okay. She never expressed concern over her children growing up apart from their father?
No, she did not.
You recall being asked this question and given this answer in the grand jury, page 15,
What date, sir?
May 3rd, 2005. Question on line 12. Now, what about Mrs. McGuire, Dr. Miller? Did she ever tell you how she felt about leaving her husband? Answer yes. Question, what did she say? She said she was also thinking of leaving him. She had spoken to her mother about that, and her mother basically told her, for the kids' sake, she should really try her best to try and make the marriage work. Stick to keeping the family one unit. You gave that answer, right, sir?
Yes, sir.
Question. So her mother more or less placed the well-being of the children above her own daughter's feelings. Answer, yes. I believe Melanie felt the same way. The Melanie you're describing here is Melanie McGuire, right?
Yes.
So you did believe, as you testified in the grand jury, that Melanie felt the same way, that for the sake of the kids, she had to try and keep the family together as one unit. Right, sir?
During that conversation, yes.
Right. Well, this conversation with the grand jury under oath was 2 years ago, right, sir?
Yes, sir.
Okay. It's a little different than what you just said just now, sir, wasn't it?
I was referring to, they had talked about getting a divorce early into our affair, and then she was upset, talked to her mother, and they decided to stick it out. At the time, around April, she felt Bill's behavior was becoming more and more erratic, and I don't think she wanted the kids around Bill.
You were asked whether you had made it clear to Melanie if you were getting a divorce, right?
Correct.
And you made it clear that you were not getting a divorce, correct?
Not at that time, no, sir.
And she never pushed you to do anything, did she?
No, she did not.
You told this jury, in regards to the timing of your consensual recordings, the wiretaps that you made on May 31st of 2005, you told them that at that time, you had not had any discussions about divorce. And that was May 31st, 2005, correct?
Can you ask the question again? Sorry.
You told this jury that at the time of your wiretaps, that, rather your consensual recordings that you recorded Melanie on, you had not had a discussion about divorcing your wife. Told them that this morning, didn't you, sir?
Objection.
Basis.
Your Honor, it's vague. I'm not sure what it is that Mr. Tappan is referring to.
Well, do you understand what I'm referring to, sir? Do you understand my question?
Whatever my answer was this morning stays the same.
Well, your answer, do you recall your answer this morning? When you're giving testimony from things that happened 4 years ago, do you recall your answer from 2 hours ago?
Yes.
And you told this jury that at the time you were making these consensual recordings, you had not had any discussions, to use your exact quote, never talked about divorcing Charla at that point. You remember saying that to this jury this morning?
Yes,
That was May of 2005, right, sir?
that's correct.
That's certainly after April of 2004, isn't it?
Yes, it is.
Okay. You understood that question, didn't you?
Yes.
Doctor? Now, Doctor, you would agree that if Melanie had some grand plan to be with you, it certainly wouldn't make sense if she were single and you weren't divorced, would it?
Correct.
And you made it clear to her that that was not happening, right?
Made it clear to her that
Melanie, that you were not getting divorced, correct?
at that time, no, I was not getting
Right.
divorced.
And you had never discussed it with her at that time, correct?
At what time?
April of 2004. I mean, we just said in May of 2005, you just told this jury you had never discussed it with her. Correct, doctor?
Correct.
Okay. And again, never once, not before the death of her husband or after, did she ever ask you to leave your wife, correct?
No, she did not.
Nor did she ever insinuate to you, doctor, directly or indirectly, that, hey, I'm available now, you want to get together? She never said that, did she?
No, she did not.
I'd like to talk to you about these recordings, just if you could pull your two transcripts up for a second. Dr. Miller. Now, let me just ask you some preliminary questions. All the recordings that we listened to today, this jury, listened to today were from either March of 2005 or May of 2005. Yes, sir?
Yes, sir.
Okay. And the March ones, March 8th to be exact, were wiretaps. You didn't know you were being recorded at that point, right?
Correct.
And March 8th, 2005 had significance because that was the day the police went to Aunt Barbara's house in Pennsylvania, correct?
That's correct.
Okay. Now, by the way, you had those two, do you have the transcripts for the session 27 and session 31?
Yes, I do.
You do, okay, great. Those were the wiretaps that you weren't making, that you weren't aware you were being recorded, right?
Correct.
You told Ms. Prezioso, but I think we took a break or something, that you wanted to make a correction on that transcript, correct?
On neither one of these, no.
Another one of those? Which transcript did you want to make a correction on?
It's one that's not present.
What, I'm sorry?
It's neither one of these.
What was the correction you wanted to make?
It was on a different wiretap.
Now, just for a second, look at that session 27 transcript for a second. I'm going to scoot over my table where I left mine. Could I just ask a quick question from here?
Sure.
Okay. You see that session 27, sir?
Yes, I do.
Okay. You see where it says, "Hi, so what's the defense?"
Yes, I do.
What you really said was, "Hi, so what's the defense attorney say?" Correct?
What I believe I was inferring was, how are we going to prove that you're innocent?
Well, you didn't, and that was a weird answer that she gave you then, right? My attorney's in Aruba?
Well, it could certainly have been a defense attorney.
Right. Said,
I couldn't hear it very well on the tape.
where's your defense attorney? As a matter of fact, on the tape, you questioned in the grand jury in 2005, you questioned that you said that, correct?
That's correct.
You recall saying that? I don't think I said that.
I do recall saying
Because
that.
that's
Yes, sir.
sort of a weird question to start out a conversation, isn't
Yes,
it?
sir.
And the answer really wasn't appropriate to that question, was it?
That's correct.
Okay. So you don't recall what you said one way or another?
Well, I would believe what your response would make sense.
Okay. Now, Doctor, I just want to take you through and ask you a few questions about the consensual recordings, the wiretaps that you made. When did the police ask you to do these?
It was the morning I was to appear before the grand jury that morning.
So, was that the 30th?
Whatever the date the consensual recordings were done, same date.
Oh, same day. They asked
Yes,
you
sir.
then and there to do that,
That's right.
and you agreed.
Yes, sir.
You had no qualms about
I had
tape
lots of qualms
recording,
about it.
Melanie.
I had lots of qualms about it.
Now, but whatever the qualms were, you were able to overcome them, and you did it, right?
Well, my thought process is that if she's innocent and she's truly innocent, and I wanted her to be innocent, that this would be the best piece of evidence that you could have.
And as a matter of fact, you asked her some tough questions, right?
Yes?
And you actually, even at one point, sir, at one point, and maybe your motives were pure on this, but you asked her to swear on her kids, right?
Yes, I did.
Because you wanted to hear what she was going to say at that point, right?
Yes, I did.
And you were hopeful the answer was going to be, "I swear on my kids I didn't do it," right?
Yes.
And you asked her that question to swear on her kids, right?
Yes, I did.
And she did swear on her kids that she didn't do it, didn't she?
Correct.
Now, I want to ask you if you could turn to the first, well, how do I identify them? They're both from May 31st, but the first one we heard, let me say it like that. Do you?
Okay.
That starts out with, "Hi, Denise."
Mm-hmm.
Do you have that one, sir?
I do not.
Oh, okay. Just want to give them a copy.
Thank you.
Okay, Dr. Will, now you're calling Melanie at RMA Associates, right?
Yes, sir.
Okay. So that would explain the sort of whispering, hushed tone she has, correct?
Yes.
She's at work, right?
Yes, sir.
Now, can you turn to page 2 for 1 second? We're not going to read back and forth. I'm just going to direct you to a few lines and ask you a few questions, okay?
Yes, sir.
On page 65, line 2, page 2, line 64. You say that they told you the day that she bought the gun, you were on the phone for, I don't know, 100 minutes,
Yes,
correct?
sir.
You see that? Now, did they tell you, did they show you the records of your phone communications with Melanie on April 26, 2004?
No, sir, they did not.
They did not?
No,
Okay. So you don't know if they were being truthful or not when they said that?
I did not know, no, sir.
As you sit here today, did they show you any phone records of the amount of time you were on the phone with her on that day?
Since that date?
Yes, sir.
Yes, sir, they did.
And it was a lot, right?
Yes, sir.
18 calls, maybe?
That
Give or
would probably
take?
be fair, yes, sir.
Okay. On page 4 of that, sir, the first line, you're asking her about the gun, and she says that first line, she actually asked you a question about the gun? No. You see that?
Yes,
I'm sorry, that's not what it says. It says about it being gone. No. Correct?
yes, I see that
Okay.
line.
And you're talking about the gun there being gone, correct?
Yes, sir.
And she's saying no, right?
Correct.
This was after, this was after the search of the storage facility, correct?
Yes, sir.
Okay. And Melanie down at line 150 says, after you say, I wish it were there so they could prove it wasn't the gun, what does she say?
Me too. Oh, I wish it was there for so many reasons I can't begin to count.
That's in response, what she's saying there, she wishes the gun was there, correct?
Yes, sir.
Okay, you understood that. So go to page 6 for a second. See on line 227,
Yes, sir.
Dr. Miller? Okay. You're talking about, now, by the way, let me just set the context here. The police are sitting there with you, correct?
Yes, sir, they are.
They're writing down questions for you to ask, correct?
Let me just see which one this one. This one we were in the car. They didn't have anything to write with.
Did they ask you, did they tell you certain topics they wanted you to discuss?
Yes, sir, they did.
Okay. And one of them was this temporary restraining order?
Yes, sir.
Okay. And you said to her, or questioned her by saying, middle of that 227 Brad Miller attribution, if it was missing, cause you put it down in the TRO, that's temporary restraining order, right?
Yes, sir.
That you didn't have a gun, right?
Yes.
And she replies, oh, because he didn't, to my knowledge. You understand
Correct.
she's referring to her husband at that point, right?
That's correct, yes.
At that point, her husband didn't have the gun, correct?
Well, we didn't know.
Correct, but this is what she's telling you.
Yes.
And let's go over to page 7 real quickly, sir. You see on line 286 where you say, they let me know they saw your car on the bridge in Delaware?
Yes, sir.
That was something they told you, correct?
Yes, sir.
That wasn't true, was it?
I have no idea.
You don't know that no one ever saw
I never
Melanie's
saw
car?
a tape with her car on the bridge.
Okay. Did they ever tell you there was no such tape, sir?
No, they've not.
But she explained to you what she did that day, that she went to Delaware,
Mhm.
and she came back from Delaware. And the
Yes, sir.
Delaware where she went is 45 minutes from Barnegat, New Jersey, from her mother's house, correct?
I'll take your word for it, sir.
Well, okay, you don't know. You don't
No, I don't know.
It's not that easy,
sorry.
but unless you can take my word for it, Your Honor, a lot quicker here.
Well, the problem is that he doesn't have any personal knowledge. He's only testifying about what he was told anyway.
True.
You'd have to take more than one person's word for it.
Okay, Your Honor. You were told by Melanie that she went back, and by noon on that day, she was in Manhattan, Midtown Manhattan, correct?
I don't know that for a fact either, sir.
I know you don't know any of this for a fact, correct? A lot of what
That's
you were
correct.
asked today, you don't know for a fact, right?
That's correct.
I'm asking you what you were told by Melanie.
I don't recall her going back to Manhattan that day, no.
You don't recall her telling you that?
No.
Okay. And turn to page 8 for 1 second. Doctor, you see where you say on line 321, I'm sorry, where Melanie says on line 321, that was Tuesday, and he was found on Wednesday. You see that?
Yes,
You say right? And Tuesday, she's saying, was the day she believes, harking back a year or so ago, she was in Delaware, right?
that's correct.
And Wednesday, she believes, was the day he was found in Virginia Beach.
That's correct.
And you say right, and she says, I'm sure they can tell how long that body's been in water. You see that?
Yes, I do.
That's sort of along the lines of the answer she gave you when you said you wish they could find the gun, isn't it? She's
Yes.
saying, I'm sure they could tell how long the body's been in water. That will
Clear
exonerate me, right?
Yes, sir.
Okay. Now, lastly, on this one transcript, no, actually, we're done. If we go to the second one, that'd be great.
I'm sorry, I'm going to need the
You
second
don't
one,
have
too.
the one, I'm sorry. Yeah, I have it. You go there.
Thank you, sir.
Okay, so the second one is also a recording you made on May 31st, 2005.
Yes, sir.
And you call Melanie on her cell phone, but at work, right?
I believe I called her at her work number.
Okay. But when you called her, you got her at her work number, right?
Yes,
But you asked her to go into a conference room.
Right.
Okay. And that doesn't appear in the transcript, but you heard yourself say that on the
Yes, sir.
second line there, the first attribution, right?
Yes, sir.
You say, can you go into the conference room on the telephone, right?
Yes, sir.
Okay. And that was so she could have privacy?
Yes, sir.
correct? Turn to page 3 for 1 second, Dr. Miller, please. On line 116, you're discussing, again, that whole thing the police told you that you were on the phone with Melanie for, as they say there, 130 minutes on the day that she bought the gun.
Right.
She spoke to you right before and right after, it says, right?
Correct.
She also tells you, she tells you in response, well, I was on the phone with my husband right before and right after. Did they tell you that?
No, they did not.
They did not tell you that?
No, sir.
Okay. That's what, but I'm saying that's what she says to you, correct?
That's what she says to me, yes.
Okay. And she asked you, did they say that to you?
No, they didn't.
On page 4, page 4. Just want to clear up a couple things here. 153, when Melanie says to you, what did Mike say? Mike, not her father, Mike, your attorney, correct?
Mike Rogers, my attorney, yes, sir.
Okay, so when she's referring to Mike here, she's referring to your attorney.
That's correct.
And on line 164, you say, yeah, and again, they think you know that you are, and you know where the gun is, and they want us to, give it up where the gun is, and I did tell them that you went back to the inaudible and looked, and you said the lockbox was empty and it wasn't there. See where you say that?
Yes, sir.
And she then says, well, I didn't say it was empty, there was something else in it, batteries and other stuff, right?
Correct.
And again, this was after the search of the storage facility with
Yes,
the
it
police,
was.
right?
Yes, sir.
Did you learn that the police opened the box in front of Melanie and there were batteries in it, sir?
I did not know that, no.
On page 5, you ask her, again, I'm sure at the behest of law enforcement on line 183, okay, but you don't know where it is? And again, she says, no, I don't know where it is, right?
Yes, sir.
Okay. She's talking about the gun there, yes?
Yes, sir.
Now, were they at this point, when it seemed like this conversation wasn't being productive, if you will, from their standpoint, did they push you to really start pleading with her at some point?
Yes.
They did, right?
Yes.
And you heard yourself several times saying, I can't take it anymore, I can't take it anymore.
Yeah, and they also suggested the idea of me leaving my wife at that point and, going with Melanie right away.
We'll get to that. You actually did bring that up here, right?
Yes.
At one point.
Yes, sir.
That was their suggestion, not
Yes, sir.
yours, okay. And by the way, I think you don't mean that they suggest you actually leave your wife. You mean to say that?
Yes, sir.
Okay. And they also told you to bring up that Delaware trip again, correct?
Yes, sir.
And Melanie responds on line 191, correct? She says, well, they basically don't want to, inaudible, so if they got footage of me on the Delaware Memorial Bridge, why don't they have it on the Chesapeake Bay Bridge tunnel or whatever? See what she says that?
Yes.
That indicates to you she knows there's no footage of her on any Chesapeake Bay Bridge, right?
Right.
Now, later this page is when, we did this before, but you ask her several times, you swear to me you had nothing to do with this, right?
Yes, sir.
And that's when you ask about the children. And you actually even tell her on the bottom, aside from all the things you're gonna lose, your kids, your job, career, you're gonna lose her in the process, you say, right?
Right.
Now, Dr. Miller, you didn't really mean that at that time, did you?
Well, I didn't foresee us being able to be together with an
Right.
investigation going on.
But did they ask you to say that I'm gonna lose you, Melanie?
No, they did not ask me to say.
That was your own volition? Now, skip that, we'll go right to page 7, if you will, sir. Again, in the middle of that page, 283, you bring it back to the Delaware trip, sir, right?
Yes, sir.
And you reference your truck, right?
Yes.
Line 283. Okay. What were you talking about when you said your truck?
Her vehicle that she's driving.
That Nissan Pathfinder?
Yes, sir.
Okay. And that was the vehicle she drove?
Yes.
Okay. And did you know at this point, sir, in May of 2005, that that vehicle was searched for trace evidence and none was found?
Objection.
Did you know?
Objection.
The objection is sustained.
Okay. Now, you then say, towards the bottom on 293, I mean, if you want us to stick together, I have to know everything before it goes any further, right?
Yes, sir.
Now, basically what you're saying is, look, if we're gonna still be a couple, you have to tell me everything,
That's right.
And she says, I did tell you everything, right?
Yes, sir, he did.
Now, page 8, sir. This is the page where they ask you, I think you said already, the police asked you, tell her you're gonna leave your wife, right?
Yes.
That wasn't your idea to say that there, right?
No.
Okay. Because you see, you heard your statements and Melanie's reactions, right?
Right.
And she was a little confused as to what you were talking about, right?
That's correct.
Okay, let's just go through that. You say,
Objection. Your Honor, I would just ask, what's the question? Could we have that up top so I can understand the reference in the transcript, Judge? Otherwise, it's just reading pieces of the transcript, which if that's what Mr. Takapine is doing, I would object.
Your Honor, I asked him a question. He said, correct, that wasn't his idea. I mean, we seem to be doing okay, and I think he's getting my questions as he's giving me the answers. You understand what I'm asking, right?
Yes, sir.
Okay, I just have a few questions on
The
this.
objection, though, is that there is more of you reading from the transcript than asking questions. And I think that is a proper objection, and I'm going to ask you to focus on the questions
Okay.
and not reading from the transcript.
Take a look, if you would, at the first 1, 2, 3, 4, 5. Five attributions. In other words, Melanie's first 3 and then your 2 in the middle.
Yes.
Okay.
Can I ask the page and lines?
It said page 8.
Lines.
The first 5 attributions, line 310, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21.
Thank you.
You're welcome. Okay. You see that?
Yes, I do,
Okay.
sir.
This is you role-playing that we're going to get a divorce, right?
Yep.
And Melanie's saying to you, why are you talking like that all of a sudden, right?
Yes, sir.
Because you had not talked like that before, right?
That's correct.
And she's saying to you, but I mean, why are you talking about divorce all of a sudden when we weren't talking about it before?
That's correct,
Because
yes.
you hadn't talked about it before, right?
That's correct.
Okay. That's it, just, that's it on that. Page 9 is the last thing I want to ask you about.
Okay.
Again, just for clarification purposes, on the top 355 line, Mike, again, is Mike your attorney?
That's correct, sir.
Okay. And after this conversation, you're winding it up here now, and again, you keep saying, I just don't know, I just can't take this anymore, right?
Right.
You've said that repeatedly.
Yes,
She there says, I feel awful. Correct?
correct.
And she felt awful for you, the way you were
Yes, sir.
expressing your feelings, correct, sir?
Yes.
Thank you. Put that down for now.
All right, Mr. Tacopina, this seems like a good time to take the afternoon recess.
Yes, Your Honor.
So, ladies and gentlemen, we'll break for 15 minutes, and we'll return at 3:05.
Dr. Miller, before we continue, I want to just go back to something I asked you earlier, questioning your memory of your earlier testimony. Do you remember I asked you about the 4:59 a.m. phone call on April 29, 2004, sir?
Yes.
Okay. And I'd asked you if you recalled leaving a message in particular, not looking at phone records, but do you have a recollection of leaving a message?
I know I left a message. I don't know what that message was.
You don't know what that message was?
No, no, sir.
Okay. And did you remember what that message was in 2005?
No.
Okay. And did you tell this jury this morning what that message was?
I said typically what I would do if I called that time in the morning, just say hello, I love you, and that would be the gist of the message.
Okay. Now, you were asked the question this morning on direct that actually was a question asking you if you recalled that message, and you said you did recall it. You didn't mean that, did you?
What I mean is that would be the general reply or the general message I would leave at that time in the morning on her
Okay.
voicemail.
So you weren't calling her that particular morning
No,
for any
sir.
particular reason?
Was I calling her for a particular reason
Yes.
that morning? No.
Other than that?
No, just to leave a message.
Okay. Now, Dr. Miller, you understood as this investigation picked up, if your affair came out, you believed if your affair came out, your life would be shattered, correct?
Yes, sir.
Your partnership would be ruined,
Yes, sir.
reputation in the medical community would be ruined,
Yes, sir.
possibly lose your wife,
Yes, sir.
your kids,
Yes, sir.
a lot of money.
Yes, sir.
And you expressed those concerns in the grand jury, correct?
Yes.
And what you had done to keep this affair going for 3 years was lie to your wife routinely about where you were going on your off days,
Yes, sir.
lie to your partners about where you were going certain times.
Yes, sir.
So you were practicing the art of deception for at least up to 3 years into April 2004.
Yes, sir.
And you practiced concealing things you were doing.
Yes.
You practiced making up events for 3 years.
I can't say I made up an event, but
Well,
I would,
like, didn't you say you had business trips to go on sometimes?
no,
You didn't that night?
no,
Tell
no.
your wife you had a meeting and go meet Melanie?
If we had a meeting, it was actually a meeting.
Oh, so you never met Melanie outside of the office?
No, we did meet outside the office, but if we had a meeting scheduled, a dinner event, we would then meet somewhere after that event.
And obviously, you told your family that you were going somewhere for work, right? You didn't say you were going to meet Melanie at a hotel, did you?
No, we did go to that meeting, whatever that event was.
Right.
Then after that was done, we would meet somewhere else.
Okay, you're not suggesting you were being honest by saying
No,
you went,
but
okay.
I'm just saying I didn't make up an event.
And you bought 2 separate cell phones in cash, right? Those
Yes.
phones with
Yes, I
the
did.
prepaid minutes?
Yes,
You paid cash for those?
yes,
And you clearly were able to fool the person who knows you best, right?
I think she suspected an affair, but I don't think she ever wanted to confront me about it.
Oh, so she was turning a blind eye, you think?
I think so.
You don't think you fooled her?
I don't think I completely fooled her, no.
And you certainly grew accustomed up until 2004, at least April, to lying, right?
I didn't have to lie that often, but yes, I did lie.
You have to lie that often, sir?
No,
I mean, didn't you lie on a daily basis?
no.
No. And you really had no problem coming up with times to get away to meet with Melanie, did you?
We did have a lot of problems meeting.
You did?
Yes.
But you were able to make it work for 3 years, correct?
Yes,
And certainly you wanted this affair to remain under wraps.
yes.
Now, you were asked about your first encounters with the police by Ms. Prezioso this morning.
Yes.
You remember that, right, sir? And she asked you, did you tell them everything at first? And you said that you didn't tell them everything you knew at first, correct?
Correct.
The words you used were, you couldn't get out all the information in the first and second meeting. That's what you
Correct.
said, right?
Yes.
But really, what you meant to say was, you lied in the first and second meeting, right?
No, never
You
lied.
didn't lie?
No,
Well, if you didn't tell them all you knew at first, you don't think that's lying to them?
well, we purposely ended the meeting because it was coming up on midnight.
How long had you been at that meeting?
About 4 hours.
So in those 4 hours, you didn't have enough time to say, I was having an affair with Melanie McGuire.
Oh, I told him that.
In the first meeting, you told them that?
Yes.
Oh, really? Where'd you meet at first?
At the police barracks in Somerville.
Okay. I'm talking about in 2004, sir, when you were interviewed by Virginia Beach police officers over the phone. You remember Detective Piquel?
Yes.
Okay. You never told him you were having an affair with Melanie
No, I
McGuire,
did
did
not.
you? You did not, right?
No,
And he asked you a whole host of questions about Melanie, didn't he?
he did.
And you didn't tell him the truth about your relationship with her, did you?
He didn't ask about the relationship between me and Melanie.
You didn't ask about the relationship? What did he ask about?
He asked about the move, who was at the move, what items were moved from the apartment.
Did he ask you why you would help your employee move her furniture?
He did not.
And you certainly didn't volunteer that you were having an affair, correct?
No, I did not.
And you hid that from the police until 2005, right?
Correct.
You didn't go into the police as the investigation picked up and said, guys, I'm having an affair with Melanie, in case you
No, I
want to
did
know,
not.
right? You thought that would be something they would want to know if they found that out, right?
I'm sure they'd want to know that, yes.
As a matter of fact, you never volunteered that to the police. They came and confronted you, right, sir?
They came and met with me, yes.
They came and what?
They came to ask me questions, yes.
Yes, but they also confronted you and told you they knew about the affair, correct?
They didn't tell me that they knew about the affair, no.
Well, you knew you were captured on wiretaps before you spoke to them, right?
No,
You didn't know that?
no, absolutely
When
not.
did they first come to you?
I believe it was sometime in March,
When in March?
March 12th.
Right. And you just heard the wiretaps from March 8th, right?
I didn't know anything about the wiretaps,
I understand you didn't know anything about the wiretaps, but they did, right?
right?
And they came to you. It wasn't a pleasant conversation, was it, that first conversation?
No,
Did they go to your neighbors, the police, with a picture of Melanie and asked if the neighbors had seen her around?
I believe so, yes.
And they made it uncomfortable for you, correct?
Yes,
Now, you were confronted, I guess you said, by, were you confronted by your partners about this
Richard Scott asked me a question, yes,
prior to the police contacting you?
yes,
Okay. And he'd asked you if you were having an affair with Melanie, correct?
yes,
And you deny that?
yes,
Okay. You understood the ramifications, if you will, if that came out, right?
yes,
That'd be in violation of your agreement.
yes, sir.
Okay. And sir, after you had these recorded conversations in May 31st of 2005, there came a point in time where you learned that Melanie was arrested in June, right?
Yes,
And then she was released, right?
yes,
And she came back to the office,
yes,
right? And you met her there when she was getting her stuff, right?
yes.
And who is Recto? You know,
Recto is one of the maintenance people there.
Okay. And he was there the night you met Melanie, correct?
We were never there at night, no.
You were never there at night?
No.
Okay. When did you, do you remember the day you met Melanie, when she was getting her stuff from the office?
I believe it was a weekend, yes.
A weekend, okay. And when you met her in RMA, you came into her office, correct?
Yes.
Okay. And did you go and lock the door and have sex with her that day?
Yes, we did.
You did. And that was in June of 2005, right, sir?
Yes.
Okay. Well, did you, had you been having regular relations with her, sexual relations with her, up until the time she was arrested?
Yes, we did see each other, yes.
Okay. Including around the time you were making these recordings, correct?
Yes, sir.
Okay. Now, that would include March 2005, April 2005, sir? May of 2005, right?
Yes.
Okay. Then she got arrested, went in jail, came out, and you resumed, correct?
We had one time, yes.
One time in June of 2005,
Yes.
right? Okay. You were asked that in the grand jury, correct, sir?
Asked what, sir?
Whether you had, when the last time you had intercourse with Melanie McGuire was, in May of 2005, correct?
Yes.
You told them it was March, after the police came to you,
Yes,
right?
that's correct.
So you weren't being truthful in the grand jury about that, were you?
Not accurate, no, sir.
Well, I understand that's a nicer word, but you were intentionally deceiving the grand jury, correct?
Yes, sir.
Okay. That's a lie under oath, right, sir?
Yes, sir.
Did anyone ever call you on that, sir?
Did anyone ever call me on that?
Yes. Did the prosecutor ever tell you you'd committed a crime?
No, sir.
Okay. It's called perjury. You understand that, right?
Yes, sir.
Okay. And did they ever ask you about that before I just did just now, sir?
Ask me about what?
About whether you lied under oath in the grand jury, sir?
No, they have not.
Okay. And had you told them that you were having sexual relations with Mrs. McGuire at the time you were making the wiretap?
At that time, no, I did not tell them that.
At any time? Later?
Yes, I have.
You had?
Yes.
And no one raised an issue that means you committed perjury in the grand jury? No one raised that issue with
No,
you,
sir.
did they, sir? No, sir?
No.
You're on their witness list, right, Dr. Miller?
I believe so.
You didn't get any immunity agreement or anything for
No, sir.
that, did you?
No, sir.
And the reason, by the way, sir, not to belabor this, but the reason you committed perjury in the grand jury in May of 2005 is because you wanted to conceal your ongoing relationship with Melanie, correct?
I still loved her at the time, yes, sir.
Okay. And you wanted to conceal that to the grand jury and the police, correct?
Yes.
And you just said something, sir, doctor. You said that you still loved her at the time, right?
Yes, I did.
Okay. And I think you recounted for this jury this morning a few instances where you didn't like hearing that Melanie and Bill were affectionate to one another on occasion, right?
Yes.
Okay. And you didn't like knowing details about their relationship, correct?
Correct.
Fair to say? Okay. There were times also you overheard heated arguments between Melanie and Bill, right?
Early on, yes, I did.
And you told Ms. Prezioso that the purchase of that new house upset you too, correct?
Yes, I did.
Sir, one of the ways you were able to, let me just ask you one thing about that day, the 29th, the morning of the 29th. You called Melanie at 4:59 a.m. That's been established, sir, yes?
Yes.
Okay. You also called her 2 more times before 7:30 that morning, right?
Yes.
Okay. What was, do you recall what was so urgent in your mind that you had to try and reach her before 7:30?
No.
I mean, you told us about your routine of leaving that one message in the morning, love you, hope you have a good day, speak to you soon.
Oh, I want to know what happened with her discussion with Bill.
Okay. So you had a particular reason for calling 3 times before 7:30, correct?
Well, I knew she
That
was going to
morning.
answer the 5 o'clock call.
Okay. And you thought you would answer the later calls perhaps?
Possibly, yes.
Okay. And you know her routine, she takes the kids to school in the morning, correct?
Right.
Okay. Now, did anyone discuss with you your phone records in regards to the regularity of your contact with Melany?
Yes.
Okay. There were times that there were 18 calls a day, correct?
Yes, sir.
Sometimes 50 emails a day, 50?
Yes.
So it was a very intense relationship in that
Yes,
regard,
sir.
correct? Doctor, one of the ways you were able to attempt to cover up your affair is to use cash to cover certain things up,
Yes, sir.
right? Okay. And you said you use cash for those private phones, right?
That's correct.
Use cash for the hotels.
Yes.
Okay. The Loop Inn was a hotel that you went to, frequented a lot,
Yes,
right?
sir.
And at the Loop Inn, you went by an alias, right?
Yes.
What's the alias's name?
I would just make up a name.
Brian Mills?
Could be, yes.
Okay. And did, which one? You clearly didn't want to use credit cards for any purchases that
That's
would
correct, sir.
raise someone's antennas, correct?
Yes.
You, paid in cash, I should say, for a saw that you purchased in 2004, correct, Doctor?
No, that's not correct.
It's not correct.
No, sir.
Well, I want to ask you a little bit about this purchase that you weren't asked about on direct, but you purchased a reciprocating saw on May 2nd of 2004,
No,
correct,
sir,
sir?
I did not.
No, sir, you did not?
No.
Okay. Do you recall speaking to, let's see, George Del Grasso?
Yes, sir.
Okay. And you went into George Del Grasso in August of last year, 2006, Doctor?
Yes.
Okay. And you went into George Del Grasso and you met him at the Whippany office, right?
Yes, sir.
And what you told George Del Grasso was that, George, I purchased a reciprocating saw combo kit on May 2nd, 2004 at the Home Depot in Bridgewater, right?
No, it's not correct.
That's not correct?
No, sir.
I'm going to show you what's been marked Defendant's Exhibit 227. I'm just going to have an extra copy.
No, I'm sorry.
Thank you. Okay, Dr. Miller, I'll direct your attention, if you will, to the first full sentence in this investigation report. I ask you to read it to yourself, sir.
On 5/16 at approximately 10 o'clock.
No,
Objection.
to you, to
I'm
yourself.
sorry, sir. Do you want to instruct the witness?
I did, but what I said was, and what you have to do is, you have to read that to yourself, these rules of ours.
Okay.
So read it to yourself, and then I'll ask you a question about it,
Okay, it's been read.
Okay. Having read that, does it refresh your recollection that you informed George Del Grasso that you purchased a combo saw kit on May 2nd, 2004 at the Home Depot?
That's not correct.
My question is, did you inform George Del Grasso of that?
No, I did not.
So if he wrote that in a report, he was wrong.
Yes, sir.
Okay. Did you come last August to their office, sir, with a saw and a receipt?
No, sir.
Okay. Did you tell them that you had a saw
Yes,
that
sir,
you
I
forgot
did.
to mention 2
Yes.
years ago?
Yes, I
Okay.
did.
Let's get there then. You went into George Del Grasso's office, or one of the investigators' offices, in August of last year?
Yes,
And was this a regular prep session, if you will, a meeting?
it was a meeting, yes.
Okay. And in that meeting, you said, I forgot to tell you 2 years ago, I bought a saw, a
No, sir.
reciprocating saw?
What I did was I provided them with a receipt from Home Depot. It was a receipt for about $113, and it said comp kit on it. And I told them I didn't know what this comp kit was, and I turned it over to them. I said I did buy a combination kit that had a drill, a circulating saw, or circular saw, reciprocating saw, and a flashlight all came together. I thought I bought it earlier than that, but I wasn't sure, and I turned it over to them to check out. Then the detective took the receipt, and he checked it out and told me that it was an air compressor that I bought.
Right. And did you ever find the credit card receipt for that saw that you bought?
No.
Okay. How did the saw get into the detective's possession?
They met me at my house, and they took it from my garage.
Met you at your house and took it from your garage?
Yes.
Did they execute a search warrant on your garage?
No.
They just came and you gave it to them and they took
Yes,
it,
sir.
right? I'm going to show you Defense Exhibit 203, okay, Doctor? Your Honor?
All right.
Yes, sir. Doctor, is that the reciprocating saw that you
Yes,
told
sir.
them about in August of 2006? Yes, sir?
I'm sorry.
Is that the reciprocating saw you told them about in August of 2006?
Yes.
Okay, Your Honor, I move that into evidence, Defense Exhibit 203, Your Honor. This is a picture.
Any objection?
Your Honor, can I just take a close look? No, no objection.
All right, D-203 will be admitted into evidence without objection.
One question. I'm just going to display it for a second. Facing me, right? That Dr. Miller is the saw you told him about in
Yes.
2006. Okay. And do you know what kind of saw it was?
No, sir.
Okay. If I showed it to you, would you recognize it, sir?
No, sir.
Let me take a shot, all right?
You'd have to tell me if it was the same serial number.
It's a little disassembled, sir. Does this look like the saw that you gave him?
It looks like it, yes, sir.
Okay. And it looks like the saw in that picture, correct?
Yes, sir.
Okay. Mark, can I get a stipulation from the state that this is the saw that was turned over to the state by Dr. Miller? I don't think that's a fact in dispute.
Judge, first of all, just so the record reflects properly, this is State's Exhibit 221. It was recovered by Investigator Del Grasso, and it could be moved in through him, but if Mr. Tacopina wants to use it for his purposes today, the state has absolutely no objection.
Thank you.
All right.
Thank you, Mr. President.
Tacopina?
Okay. So, you heard Mr. President, correct?
Yes.
So, is this all they took? These
Yes,
three
sir.
pieces right here?
Well, was it in 3 pieces?
It was in one piece?
Yes, sir.
Okay. Do you know what happened to the rest of that stuff, Dr. Miller?
It's still in the garage.
It's still there?
Well, I had since moved, but yes, it's all there.
Okay, it's still in that little case?
Yes.
And I'm going to hand you what I've marked as Defense Exhibit 234. Yes, sir. Sir, this is a Ryobi 18-volt reciprocating saw, correct?
Yes, sir.
And what I handed you was a printout from the Home Depot website. Is that a description of the saw that you have?
It's not the same, no.
It's not the same? What's
No,
different
sir.
about it?
This is a different kit.
It's a different kit?
Yes, sir.
Okay, well, what was in your kit, sir?
There was a flashlight, power drill, circular saw, and a reciprocating saw.
Okay. And your reciprocating saw comes with two blades. Is the other blade still in that kit?
No, they took them.
They took both blades?
Yes, sir.
How many blades do you see?
I see one blade there.
And this is not a blade, right?
Right.
Doesn't appear to be a blade.
Your Honor, I'm going to object. Detective Del Grasso, Investigator Del Grasso recovered it. It's unfair to the witness to be asking that question. I have no problem with Mr. Tavernino displaying it, Your Honor, but the question's
It's
about...
unfair to ask him how many blades were taken?
No, Your Honor, the shaking of the saw in front of the witness, I would object to that.
Excuse my shaking of the saw. I was looking to see if there was another blade in there, Doctor. But my question to you was, how many blades did they take?
They took whatever blades were there.
And there were two blades, correct?
Again, I wasn't there. So
Well, I know, but you didn't just say that. You want to go back just a minute ago, Doctor?
What?
You said there were two blades that they took. Didn't you just say that?
I believe they took two blades, yes.
And based on you telling them this, and by the way, why did you feel the need in August of 2006 to tell them about your reciprocating saw?
I didn't tell them about my reciprocating saw. I told them about the receipt, and that I
Okay.
didn't know what that receipt was for.
You went into their office to have a meeting.
Yes.
I want to just make sure I understand this. And you thought it was important to bring in a receipt for the Home Depot for May 2nd of 2004 for that meeting?
Yes.
And why would you think, hey, guys, here's a Home Depot receipt from that
Right.
day?
And I didn't know what a com kit was,
Why would you bring in a receipt whether you knew what a comp kit was or not?
because I wanted to make sure it wasn't that piece of equipment right there.
Oh, so you brought in a receipt, not a receipt that you thought represented the saw, but a receipt to show that it wasn't the saw?
No. Receipt that I didn't know what it was for.
Okay. But my question is, why in August of 2006, 2 years after you're thrust into this investigation, a year and 3 months after you are working, if you will, with the New Jersey State Police, why do you then come forth with this information?
Because I just got the receipt back from Citibank.
You got a receipt back from Citibank?
Yes, sir.
On a purchase you made on May of 2004 in August of 2006.
Yes, I had to request it,
Well, why did you request it, sir?
because I want to know what I bought at Home Depot.
Okay. Why did you want to know what you bought in Home Depot in 2006? Why was your curiosity so taken by that?
Because I wanted to know where I was on May 2nd and May 1st.
You didn't know where you were?
I couldn't tell you if I was at Home Depot unless I had a receipt from there.
So when you got this receipt from Home Depot, did anyone ask you to do this, sir, by the way?
No.
Okay. In August of 2006, you decided at that point, after you testified in the grand jury twice the year before, you decided at that point to start putting your whereabouts together?
It took a long while to get the receipts back from Citibank. We didn't have any of those receipts from back in 2004.
So you give them this, you tell them about this reciprocating saw, correct? Or you tell them about this receipt.
They asked if I had a saw
When did they ask that question?
that day.
Okay. For the first time in all your interviews, in August of 2006, they asked you if you had a saw?
Yes.
Out of the blue?
No, it's because I said that receipt, I didn't know what it was for. It may have been for this combination kit.
Okay. So after you said that, at that point they said, do you have a saw?
Yes,
Okay. And then they said, you said yes, right?
yes,
And they said, well, we better go get that saw then, right?
yes,
And this is August of 2006?
Yes.
After Melanie is arrested the year
Yes.
before? And they take the saw and two blades and whatever else is in here, correct?
whatever they put in their report, yes, sir.
Okay. You have any further discussions about that, sir?
No, sir.
Okay. By the way, did they ever execute a search warrant on your house?
No, sir.
Did they ever execute a search warrant on your car?
No, sir.
They didn't take any dustings or vacuum it or anything?
No, sir.
How about your garage, anything like that?
No, sir.
Okay. So the Red Roof Inn visit that we talked about this morning
Yes, sir.
in, what was that, May 1st of 2004?
Yes.
Yeah, I don't need it anymore.
That's okay.
Don't touch it. That was when you visited Melanie early in the morning before work?
Yes, sir.
Okay. It was about 5 a.m.?
Yes.
Okay. And she told you she was staying at the Red Roof Inn after the fight, correct?
Yes, sir.
Told you she dropped the kids off after she picked them up from school on the 29th at the parents'?
Yes, I believe so.
Okay. And you came unannounced, by the way, right?
I called first.
Did you reach her?
Yes.
Okay. And you told her you were coming over?
I asked if I could. Yes, sir.
Okay. And when you got there, there were 2 beds, right, in the room?
Yes, sir.
One was fully made,
Yes,
wasn't
sir.
disturbed, right?
No.
And the other one had
She
Melanie?
was sleeping in, yeah.
Okay. And she only had one overnight bag with her,
Correct.
correct? Okay. And did you give her a silver and opal ring that morning, sir?
No, sir.
You did not? Okay. Now, did you suggest to her that it wasn't a good idea for her to go back to the apartment that morning? Did you have that discussion?
Yes.
Okay.
I didn't have it that morning. No, sir.
When did you have it, sir?
It would be the morning of the 29th.
When you spoke to her after she
Yeah.
told you about the fight? Okay.
Yes, sir.
Now, you also told the jury, Dr. Miller, that you helped out with, you were there for parts of the move, correct?
Yes, sir.
Okay. And you described your conversation with your wife about how you wanted to help out because this was a time of need, right?
Yes.
And you were in and about the Woodbridge apartment, right, sir?
On that Saturday?
Yes.
Yes, sir.
Okay. And I think you said you were there the day in the basement. Were you in the basement dealing with weights and stuff
Yes,
like
sir.
that?
Took apart the weight set.
And the basement didn't appear to be anything unusual about it, correct?
No, sir.
There was no malodorous scent?
No, sir.
There's no blood stains or anything, right?
No, sir.
Okay. And there certainly was no scent or smell that was outstanding in the upstairs part of it.
No, sir. I didn't notice anything.
For instance, it didn't smell like a morgue?
No, sir.
No, okay.
And I mean,
And
there
you know
was-
what a morgue smells like, right?
There was, 6 or 7 people through that apartment that day.
Okay. And do you remember the date?
It was the Saturday before Memorial Day.
Right. It was that Memorial Day weekend, right?
Yes, sir.
Okay. And the nurse that you were talking about, Melanie, was either selling or giving some sort of TV unit, hutch to or something?
Yes.
That was Lori Thomas?
Yes, sir.
Okay. And did you see Lori there with her boyfriend?
I did not, no, sir.
Okay. You were in the basement with the weights at that point?
No, this was a different day of the move.
What was that day? That was the Saturday?
I don't know what day that she actually came over to pick up the hutch, but earlier that day is the day I took the TV down.
Okay. So you were there. Was the hutch still there when you were there?
Yes, sir.
Okay. So when you were there, the hutch that Lori Thomas was coming to take was
Mhm.
still there.
Yes, sir.
So she came after you, obviously.
Yes.
And you didn't notice anything unusual. I know you said you didn't smell anything. You didn't see anything unusual either. in the
Melanie and
apartment.
Celine were there, but no, there was no unusual odors or anything unusual at all that I noticed.
Furniture was there, right?
Yes,
Okay.
all of it.
The bed?
Yes,
right?
sir.
And Melanie, the day of the move, were you present the day of the move?
Yes, I was.
Okay.
The whole time.
With Melanie's parents, right?
Yes, I was.
And was Celine there?
No, Celine was not there.
Okay, right. Melanie was there.
Melanie was
Melanie
not-
was not there either, right?
No, she was not.
Melanie actually was babysitting her children, correct?
Yes.
Yes, sir?
Yes, sir.
Okay. And that's why she wasn't at the move, correct?
Right, correct.
Okay. By the way, Melanie told you about a second trip down to Atlantic City, correct? May 18th?
Yes.
Okay. And that was, she told you she went down to Atlantic City on May 18th to see if the car was still there, right?
Yes, sir.
Because she told you her husband, Bill, was due back at work that day after his 2-week vacation.
It was around that time, yes, sir.
And she called and found he didn't report to work, right?
That's correct, yes.
So she went down to see if the car was still at the spot that she left it.
That's what I understood, yes.
few more things, Dr. Miller, and we'll be done. I'd like to ask you about the prescriptions that we talked about before. Do you have the hard copies of these prescriptions, sir?
No, sir, I do not.
Okay. Well, you were given this State's Exhibit 1125, this chart, right, sir?
Yes.
You identified some of those prescriptions on the chart as prescriptions that you did not write.
There was a few, yes, sir.
But how would you know that without seeing the actual prescriptions?
I know that the only time that I had called in a prescription for Xanax for Melanie was on the 29th. There was 4 other prescriptions filled, whether they were phone in or written, on different dates.
Okay. And does that allow for refills when you called it in?
I honestly don't remember if I had
You don't
refills
remember,
on
do
or
you?
not. No.
Because you never saw the actual prescriptions, did you,
No.
sir? So this chart that was shown to you, you didn't comprise this chart, did you, sir?
No, sir.
And this chart's not comprised of hard prescriptions that you could actually compare?
No, sir.
So when you were asked all these questions, you were answering them based on what's on here, not in your own recollection.
Well, my own recollection would be that I called in a prescription for Xanax on the 29th.
But as far as these other things that you had identified here, other prescriptions that you didn't write, you're going based on your recollection that you didn't call in a prescription that allowed for refills.
Correct.
You don't know one way or another.
Correct.
Okay. And how do you know you wrote the other ones then, if you never saw these? How do you know you wrote the one from, I don't know, 2403?
I don't know for sure, but it would be, the medication itself would be something I would have written for her, yes.
You're making an assumption that you
Yes,
wrote
sir.
these. So, for all intents and purposes, I mean, you could have perhaps not written any of these prescriptions, for all you know, right?
That's possible, yes, sir.
And I think you said it was the practice at the time at RMA that nurses would sign the prescriptions for the doctors,
They would
correct?
sign them, or they would pre-fill them out, we would sign them, yes, sir.
But sometimes nurses, not just Melanie, nurses
No.
would sign them, right?
It wasn't just Melanie.
Okay. And I'd like to show you what you were shown before, State's Exhibit 239 and, I'm sorry, State's Exhibit 302 and State's Exhibit 222. So first I want to show you State's Exhibit 239. Let me just verify that that's right. State's Exhibit 239. Doctor, I'm just going to come up here for a second
Okay.
with you, all right? You saw this before, correct?
Yes, I did.
And that's a prescription that Melanie wrote?
I believe so, yes, sir.
Okay. And you knew she was writing that, right?
Most likely, yes.
Because it was for some
Yes.
medication she needed?
Right.
Okay. And that's her handwriting?
Yes, sir.
That's her handwriting?
Yes, sir.
And
That's
that's her signature
Of
of
mine.
yours?
Yes, sir.
Right?
Yes.
Which she was authorized to do?
Yes.
right? We'll just put this up for the jury. Okay. Okay, and you agree that to everything you just said, that that's her handwriting?
Yes, sir.
correct? Conversely, that, and by the way, that is not your signature, right?
That's correct, sir.
That's, whose signature is that?
I believe it's Melanie.
Right, because that's the way Melanie used to copy your signature, correct?
Looks similar, yes.
Certainly very different than what I'm going to show you now is State's Exhibit 222. Very different than that, right, sir?
Yes, sir. No, it doesn't look like.
And this handwriting is very different than that, correct, sir?
Yes, sir, it is.
And this handwriting is tilted to the left, almost as if a lefty wrote it, right?
Looks that way.
Okay.
I'm certainly not a handwriting expert.
No, I know that. I know that. That's why I'm asking you these questions now. What's behind me on that board right there is Melanie McGuire's handwriting. At least it appears to be to you.
Yes.
Okay. This certainly doesn't, does it?
It could be her printing, but it's certainly not her handwriting.
Could be her printing?
Well, again, I'm not a...
Could be mine too, right?
Right.
Okay. I mean, you don't know that this is, have any idea that this is Melanie McGuire's or not, right?
No, without a doubt, no.
I'm gonna put this up. Let's try and get those in. A little different, those two handwritings, right?
Well, one's not even handwriting, it's just printing.
Right. One's printed and one's script, right?
Yes, sir.
And one, this one here, Tiffany Baines, tilts to the left, as if it were written by a left hand, correct?
I'm not expert on that, so
I
I
know
can't
that.
tell you.
And the signature is certainly the one Melanie, that's Melanie signing your name, right?
Right?
And that's a little different than that, right?
Yes, sir.
Okay. So you don't know whose handwriting this is, right?
Not, yeah, not without any definite, no, sir.
Okay. And I understand you're not a handwriting expert, but you see, you were asked these questions before on the record, so now we have to do this,
Understood.
okay? This handwriting is not recognizable to you, is it? When I say this, I mean this one right here.
The printing looks similar to what I've seen Melanie print before.
Really? And that certainly is a far cry from that, right?
That's certainly her handwriting, her script, yes.
This is, correct?
Yes.
Okay. And the signatures are certainly different. They're both in script, right?
Yes.
Okay. Now, did anyone suggest to you that Melanie wrote that, sir? When
No,
you
sir.
were prepping for your meetings?
No, sir.
Okay. When did they first ask you whose that looked like? Whose handwriting?
It might have been during one of our meeting sessions.
Recently?
I don't know if it was recently, but probably within the last 4 or 5 months, yes.
Okay. Did you compare any of Melanie's handwritten
No,
stuff
sir.
to this?
It's just by memory.
Just by memory?
Yes, sir.
Okay. And when I asked you 2 minutes ago, you said you really didn't know whose this was, right?
Not definitely, no, sir.
Not definitely. So it wouldn't be fair to say you recognize that to be Melanie McGuire's handwriting, right? Wouldn't be fair to say that.
It looks like her printing, but I can't say it's for sure her printing, no, sir.
So you want to qualify the earlier answer, correct?
Yes, sir.
Your Honor, I could finish up with Dr. Miller very briefly. But one thing I will want to do is have a sidebar. At least I want to address what happened here regarding that that printout. So I just want to leave a few minutes for that, Your Honor.
Okay.
Okay. All right, Dr. Miller. You sent Melanie and you conducted a email relationship, if you will.
Yes.
As well as a phone relationship, correct?
Yes, sir.
And you sent Melanie emails from time to time, right?
Yes.
Okay. I'd like to show you Defendant's Exhibit 231 and 232. Here goes. 231, 232.
Okay.
So are those emails between you and Melanie McGuire?
This one is not.
Which one, sir?
Well, this one I forwarded to Melanie, yes.
That's okay.
This is 232.
So forgetting about the top part, just focusing on what you forwarded to Melanie. And you're talking about 232, correct, sir?
Yes, sir.
So don't worry about what she did. But I'm talking about the part that you sent to her. You sent Melanie an email on September 27, 2004, correct?
Yes.
Okay. And this was an email about an article regarding the investigation, correct?
Yes.
And you sent that to Melanie?
Yes, I did.
Okay, Your Honor, I'd offer Defense Exhibit 232 in attendance.
Preciosa?
Judge, no objection.
All right, D 232 will be admitted into evidence without objection.
And turn to 231, sir. The short email, correct?
Yes, sir.
And the original email, by the way, let me just do this, Your Honor. I'm not going to It's a couple pages of email. I'm not going to go through it now. But
Judge, I'm sorry to interrupt. Can we approach for a moment?
Your Honor, could I just clarify one thing for the record for those prescriptions? Okay. Oh, never mind. Thanks, Michelle, sorry. My bad. Doctor, I just want to verify just one thing. So we're identifying these properly for the record, these two prescriptions. The prescription that I've been referring to is State's Exhibit 239. I think is actually State's Exhibit 302, but anyway, it's the one that Melany, with your authorization, wrote to herself on 1/15/04, correct?
Yes, sir.
Okay, and signed your signature the way she normally does, right?
Yes.
And this other one is properly, I think, been identified, Your Honor, as 222. Okay, that's the one with Tiffany Bain, correct?
Yes, sir.
By the way, when you were saying maybe it's Melanie's handwriting, maybe it's not, you didn't know, you're not a handwriting expert, did the state tell you that a handwriting expert did not find that this was Melanie's? Did they tell you anything about
They
that?
didn't tell me one way or the other.
Okay, Your Honor, if we're not going to finish today, I might as well stop.
All right, members of the jury, seems like we have a little while more with this witness, so at this point, we're going to recess for the evening, and we will resume tomorrow morning at 9 a.m. Report to the jury assembly room at that time. All right, Mr. Tacopino, you had indicated that you wanted to address something about the exhibits.
Yes, Your Honor.
Ladies and gentlemen, please be seated. We're not recessed yet. Obviously, if anybody wants to leave, you're welcome to leave, but we're still in session for a while longer.
Your Honor, I'm going to ask that any of the testimony related to State's Exhibit 1125 be stricken in front of this jury. And this exhibit, which quite frankly I don't recall if it was offered or not. If it was offered, I asked to be removed from the evidence roll, but the exhibit roll. But in any event, what happened here was...
Excuse me one second.
Yes, sir.
Ms. Preciosa, can you explain to Mr. Romanish what we're doing? I think it's still related to, you know, the issues that we previously discussed.
I'm sorry, Your Honor, I just came in because the witness was off the stand.
I know, but we're addressing something about that testimony.
That's fine, Your Honor, I did not realize that.
That's okay.
Anyway, Your Honor, we heard on cross-examination that he was not relying on prescriptions to make these representations to the jury, that he did write certain things and didn't write certain things, that he was going on a chart that he didn't comprise, that he didn't put together, and it was not based, at least as far as he was concerned, on the actual prescriptions. That he doesn't know if the prescription he wrote on the 29th, orally called in on the 29th, called for refills or not. He did not have that basis of knowledge. He was testifying off of this chart as if it was a composite of his prescriptions that he had reviewed. I think that was very misleading, and I asked that be stricken. This is worthless to this witness as it would be to me testifying about it. He had no basis of knowledge of any of this. That's why I asked him, how do you know you didn't write any of these? He said, I don't. And that's not how this came on the record. On the record, Your Honor, this was presented to this witness, and he testified that this was a composite of prescriptions that he had either written or were in his name. And he was asked questions based on that premise. And I think that was terribly misleading to the jury, and I don't think it was, quite frankly, in this witness's, it was unfair to the witness, quite frankly, because on cross, he stated, I've never seen these hard scripts. I don't know who put this together. I don't know if it's accurate or not. And I don't know if I called any of these in or didn't. Except he knows he called one prescription in on the 29th. He recalled that. That I agree he could be able to testify to. But the rest of this, I think, is misleading. And I don't think that testimony should stand.
Precioso, I'd like to see a copy of the exhibit we're talking about at some point. I'd rather have one without the blue stickies on it, though, if I could. Might stick to my hand or something.
We
Judge,
just got this today, by the way.
Okay.
you can use our copy. It was provided to the defense
Today?
in advance,
Oh, thank
in
you.
advance of it being used. Well, Mr. Tappan,
Well, a
at
minute.
least it was provided before it was used, though, unlike your exhibits.
Oh.
But, Your Honor,
No,
what
Your Honor,
that
see,
is,
we're not doing that.
Counsel,
Your Honor.
counsel,
If we're gonna do
please.
that, Ms. Prezioso, in this case,
Mr.
we're still
Tacopina,
giving us discovery.
Mr. Tacopina, I'm
As are
speaking.
you.
Now, let's just hear about the exhibit and the request, the application by Mr. Tacopina, Ms. Precioso. I don't really need to get into other issues.
Judge, what you're holding is a summary chart. It is a composite. It reflects records that were received from Walgreens Pharmacy regarding prescriptions from Dr. Miller, as well as subpoenaed records from defendant's health plan with what she received. It's a composite. It reflects records that we have that have been turned over, and it simply puts everything in composite form, much along the line of discussions that were had yesterday regarding phone records. It is a composite of records that are here. If Mr. Tacopina wants the full records admitted, that's something that we have no objection to doing, that's fine. But that's a composite that was reviewed by the witness, and yes, Judge, it was provided to defense in advance. I also went over and showed it to Mr. Tacopina before I used it, and at that time, he had no objection. Now, Your Honor, what I was planning on doing in redirect is pointing out certain things about Mr. Tacopina's cross that I would strongly prefer to do with the witness first. But, Your Honor, it's common knowledge that refills don't change the quantity of the pills, it doesn't change the dosage of the pills, and certainly when a prescription is called in, there is no hard copy prescription. The witness testified that nurses call in the prescriptions, and this was what was called in and prescribed and dispensed by those pharmacies. So, Your Honor, the people stand by that, the state stands by that exhibit. If Mr. Tacopina wants the underlying records in, I understand and will proceed to do just that.
Judge, that is so off point. My point is not that I want the witness, before he testifies to this, to have the underlying record. It's not for me to
Well,
have.
maybe you do and maybe you don't, but the point is that that's not what you're asking for. You're asking me to strike his testimony and to tell the jury to disregard his testimony because his memory seems to be rather imperfect with respect to the entries on this chart. Now, after looking at the chart, it seems to me that as a general proposition, Dr. Miller has testified that he had both written and called in prescriptions for the defendant for various, conditions or illnesses. And of course, he also testified that there were certain things that he would have never prescribed. So that seems to allow him to review a chart of the prescriptions that the state represents all come from Walgreens and to testify about the chart. Now, your cross-examination reveals that his memory may not be as precise as his direct examination would have suggested, but that's why we have cross-examination. And you're still on cross-examination, so you can continue to press him. But frankly, even if he ends up admitting that he doesn't remember most of the items on here, then you've made your point, but the state may still introduce the business records of Walgreens if they care to.
Sure.
So I think that the remedy that you're seeking is really one that is in your hands through cross-examination. And of course, Ms. Precioso indicates that she intends to have some redirect. So I think that by the time that Dr. Miller leaves the stand, there will be no likelihood or possibility that his testimony in this regard will have misled the jury. And for that reason, I can't order that it be stricken.
Fine, Your Honor.
Judge, I have just a brief application. I think will have to be addressed tomorrow in a little bit more detail, but.
Okay.
There are two issues that I believe were either Giglio material or Brady material that we never received. Several weeks ago or last week, Dr. Jackson testified, the toxicologist, and testified that he performed a test. The New Jersey State Police or medical examiner performed a toxicology test back in November or December of 2004 that showed that the presence of chloral hydrate and its byproducts were not in Mr. McGuire's blood, the blood that was taken at the time of his autopsy. I went back, and I don't believe we ever saw a report that states that. I would have liked to have seen that before he testified, number one. Number two.
Are you suggesting that you were not aware and that it had not been represented somehow in these proceedings, that there was no finding of chlorohydrate in Mr. McGuire's
No.
system?
Judge, what was represented is that there was no finding in his system because they didn't know what they were looking for. But what Dr. Jackson said is, actually the test they performed, when you go back and look at it, you could determine, or you would be able to make a determination that there's no chlorohydrate based on the test. That's something we didn't know. Certainly I didn't know. The second application is, notwithstanding Dr. Miller's testimony on cross-examination as compared to his testimony on cross.
Well, let's stay with, can we
Okay.
stay with Dr. Jackson? I'm not much of a multitasker, and I'd like to do one at a time.
Sure.
You know. Ms. Precioso?
Yes, Judge, I disagree with how Mr. Toronto is characterizing Dr. Jackson's testimony. My understanding of what happened is that there was testing that was done by Dr. Jackson's lab in November of 2004, and that after the discovery and the linkage of the chloral hydrate prescription to the defendant's computer and to the RMA prescription pad, when he tried to do further testing, there was no samples available, so he went back and looked at his original data when he tested back in November of 2004 to see if there was any way from that original data to discern the presence of chloral hydrate or its byproducts. It was not a test specifically done for chloral hydrate, and I believe on cross, Dr. Jackson even said if he had known he was testing for chloral hydrate, he would have done a different test. But just the same, having no further sample, he went back and reviewed his data and still was not able to discern anything.
Go ahead.
That original data was turned over to the defense, and that's my recollection of the testimony, Judge, and I would submit that certainly is not Giglio or Brady material.
Judge, I don't think that's his testimony, and what I asked then is that the state show us, because certainly our expert wasn't able to glean what Dr. Jackson testified to on cross. All I asked is that the state then provide that information, what they think, what exhibit or what discovery would have shown that result.
Well, let me ask you this, Mr. Toronto. First of all, I must tell you that without checking my notes, I would tend to have the same recollection as Ms. Precioso about the testimony of Dr. Jackson, but let's assume for the moment that the testimony is a little more like what you recall. So what would you have done differently, and how does that prejudice you that you haven't received that material?
Certainly, Judge, we certainly could have handled the issue of the chloral hydrate differently. We could have opened more affirmatively to the issue that there was no indication of chloral hydrate in the system. That test definitively showed that but for this argument that maybe the blood was in some way, or the ability to do the toxicology examination was in some way diminished based on the passage of time from the blood getting from the body being retrieved and the original test being performed, but for that as a possible scenario, this report, or this examination that was done back in 2004, the end of 2004 by New Jersey, definitively states that the chloral hydrate, neither chloral hydrate or its byproduct, was found in the blood sample based on that test, and that's a test that certainly tested for those compounds.
Well, first of all, I don't believe that is a. I don't think that's the only interpretation of his testimony, frankly. I think his testimony was that going back in time, many months later, it would be very difficult, but he tried and he couldn't find anything. And my notes on your opening statement reflect that you emphatically stated that there was no chloral hydrate found in Mr. McGuire's body.
By Virginia Beach.
Well,
But Judge, there's a difference. There's a difference. Well, you know what?
well, I
Judge?
know there's a lot of differences. My point is that you're asking me to make some type of a finding that the state failed to turn over some evidence to you that negates guilt or suggests a defense. That isn't completely accurate as I recall it. And secondly, you're asking me to conclude that somehow the defendant was prejudiced by that omission. And what I'm suggesting to you is that from long before this trial began, it was your position and you had knowledge that there had been no finding of chloral hydrate in Mr. McGuire's body. The only real dispute here was, why. And, the state, of course, takes the position that the why is because they weren't looking for it right away, and by the time they were looking for it, it has a very short half-life. And, of course, you're taking the position that it was never there to begin with. I don't really see how Dr. Jackson's report many months later, or lack of a report many months later, changes anything. You're calling an expert to address your interpretation of the issue. You've opened on your position. You've cross-examined Dr. Jackson. I can't imagine anything would have turned out any differently. So on that issue, I just think that I'm not sure what your application is, frankly. What are you asking
What my
for?
application was, because I think this is something that was going to require a little bit more analysis, what my application was is to have the state produce to us what did that report that Dr. Jackson conducted in, or at least direct us to Bates numbers of the report that Dr. Jackson performed back in late 2004. That's what I'd settle for at this point. Number two,
Was there a supplemental report that was done, or did he just go back and conduct tests and not do a report? Or did you turn over the supplemental report?
Judge, the supplemental report is in letter format. The last time this issue came up, I had it in my hand. I apologize for not having it out. I wasn't expecting the issue. And it laid out reasons why Dr. Jackson was explaining the volatility of chloral
Right.
hydrate, the short half-life, and whatnot. The original report was turned over by Dr. Jackson. I know the
No, but he went back and he did additional testing, right?
in
Or he reviewed his data.
He reviewed
He didn't
the
do
original
additional
test.
testing.
He looked at it and said, I can't discern
Okay.
it here.
Are there any notes, is there any supplemental report, or is it just contained in that transmittal letter that you're talking about?
There is no supplemental report that I'm aware of other than the.
So his conclusions from the supplemental review of the data, the secondary review, are embodied in that letter,
Yes,
which was turned over to the defense.
yes. It doesn't, it explains the possible reason for the absence of chloral hydrate.
Okay.
well, Judge, we'll
So there's nothing else?
well, okay, we'll show you what I think Ms. Prezioso is speaking to, and I'll see if that's in fact what she's speaking to, and then I'll show you the bench papers that I asked for and received, I guess, a day before he testified, if not the day he testified. But I'll put that together for you, Judge.
Well, wait a minute. So you got bench papers. You're talking about his, notes of his
Yeah.
review? So you got them?
I got them the day he testified.
Okay. And so how did that prejudice you?
How did it prejudice? Because I'm not a toxicologist, and apparently he's testifying. If those bench papers are what he's referring to, well, that's how it prejudiced us. I want to just simply see, Judge, he was testifying to a report or a test that was done in late 2004, and I just simply want to see what that report is. Where is the report in the discovery? If it's in the discovery, so be it. I'm just waiting for a Bates number, that's all.
And, Your Honor, I think it's important that the record reflect that when the bench, whatever the bench calculations were handed over to the defense, they requested additional time to consult with their expert, and we didn't call Dr. Jackson that day. We didn't call him until we got the go-ahead from the defense attorneys. So,
Okay. I frankly, Mr. Torano, at this point, I don't see any glaring problem here that needs court remedy, but you're always free to reapply.
I will, Judge.
All
And
right.
the second issue is, today we were told on the stand that Dr. Miller admitted to committing perjury in a grand jury, and that information was put forth to the state prosecutor at some point, obviously before he testified, and we never got that information. I would submit that that's clear Brady and Giglio violation.
Your Honor, I would disagree with that. First of all, on a few points. Dr. Miller, it was clear, and it was even elicited on direct, that this was a man who was in a difficult position, and his cooperation, I would say, increased as he got further away from the defendant. Secondly, in New Jersey, under New Jersey state law, perjury is a false statement under oath as to a material fact that the grand jury is investigating. The grand jury was not investigating whether or not two people were cheating on their spouses. It was a homicide investigation. And I don't think it shocks anybody that this man who was in love with this woman continued to have feelings for her, and as with many witnesses, underplay how long these feelings are going on. Did it come up with Dr. Miller? Did he admit, it was probably last night, that he still had feelings for her? That, in fact, is correct, and it was clear that this was going to be the subject of cross-examination. And in fact, the thrust behind impeachment material is to alert the defense so that they could confront the witness with it, and it was clear that that was going to happen. As a matter of fact, you know, the whole describe your cooperation with law enforcement was seeking to bring it up right on direct. So, Your Honor, the state would disagree as to the fact that whether or not he was still in love or still had contact with Ms. McGuire constituted perjury. And secondly, it was clear that the defense was aware of the situation, and it's clear by their cross that they were aware of the situation.
Judge,
Could I just say one thing?
Sure.
No,
Oh, you're not going to double team me now, are you?
Just from the right, a little from the left. So we weren't aware of anything. I mean, that's an absolute misrepresentation. We were not aware. He said under oath. And I don't know how we're now protecting a lie under oath, because the doctor said that's what he did. He intentionally lied under oath regarding whether he was still involved with a subject in a murder investigation as he was working with the police. I mean, he's one moment taping her, the next minute having sex with her. He lied under oath about that, Your Honor. He lied under oath at the time leading up to it. They clearly, by his testimony, they had a conversation about the fact that it was ongoing and the fact that his testimony in the grand jury was not truthful. And we were not notified of that. So I don't want to hear clearly, I knew about it. I knew about it because I cross-examined.
I think the state concedes that you were not specifically notified, but you have just said that you were not aware. Now, are you saying to me that the first time that you had any knowledge or reason to believe that the doctor was still having relations with the defendant was as a result of your vigorous cross-examination here today?
Was vigorous, wasn't it, Your Honor?
Well, you're not saying that, are you?
No, sir.
Oh.
But what I am saying is that he acknowledged, instead of making a mistake, he acknowledged lying under oath to protect himself, to cover it up further, and told that to the prosecutors. And a lie under oath, Your Honor, is something that we should have.
Well, you see, that may be true. It may be that even if it's not perjury, Ms. Precioso, it is false swearing, which doesn't have a materiality requirement. And it may be that if investigators speaking to him really put it together and really focused on the idea that in his 3 sessions before the grand jury, he misled or concealed that particular element of his testimony, I think probably you should have been advised of that. But then we get back to the second prong of this application, which is, okay, so let us assume that there was an omission on the part of the state to turn over some discovery by failing to memorialize some inconsistency in Dr. Miller's statements that they come to learn about after he makes those statements in subsequent interviews. Then the question again becomes, okay, so how does that prejudice the defendant? And what would you have done differently? And the answer to that, in my view, is it does not prejudice the defendant, nor would you have done anything differently, because you very skillfully cross-examined him here. You're not even done cross-examining him. You got him to admit that he lied to the grand jury and that he intentionally did so. So for purposes of impeaching his credibility, it seems to me that you have not been prejudiced at all. Indeed, it may have worked to your advantage. And that is really the question that the court has to deal with. A criminal trial is not a play. It's not a scripted event. There are times when people say things differently at trial than what they say earlier. One remedy for that is a final jury instruction that explains to people how they should evaluate inconsistent statements. Right? Another remedy is effective cross-examination. We've already seen the first remedy at play, and the second remedy will, of course, be the court's final instruction, where I assure you that with respect to any witness that testifies, if there are prior inconsistent statements, the jury will be advised as to how to evaluate them.
Judge, here's the issue, though. What if,
And we do have, by the way, I think you're aware that if there is a false in one, false in all instruction to the jury, and you both know what that says, well, three of you, I'm sorry, know what that says. So I think that we can address that issue on Friday, when you're all supposed to submit to me your request for final instructions to the jury.
okay. Judge, here's the
You
issue.
do remember that, right?
Yeah.
Okay, good. But I really don't think, counsel, that you've really been prejudiced by this. I think that you were already prepared to ask these questions. You did ask these questions, and you established the point that you were trying to make.
Judge, here's the issue, though. What if Mr. Miller, Dr. Miller said, no, he was truthful, or he didn't lie to the grand jury? We're stuck with that answer. And my problem is...
But that's what if. That's not what happened.
but Judge,
you want me to give you some kind of a remedy based on a hypothetical
Judge,
that didn't exist?
But Judge, here's my question. Here's my issue, rather. That wasn't even a close call. That was not even a close call. We should have had that. That was perjury, false swearing in front of a grand jury. It wasn't even a close call. What don't we have? What are we not asking the right questions? That's clearly
It's a
impeachment material.
much closer call than you suggest, Mr. Turano, because if you have investigators who are reviewing thousands and thousands and thousands of pages of transcript and discovery, and it's going back and forth as it has been for a couple of years right now, when someone ends up testifying at variance with an earlier statement, I'm not so sure that that immediately is focused on in terms of its significance. But again, that really begs the question of what is the proper remedy at this time? And what I've said to you is, even if it turns out that the court were to conclude that this was clearly information that was conveyed to them that they should have focused on and recognized the conflict and then should have reported that to you, it really hasn't changed anything in these proceedings. It surely hasn't surprised you, and it surely hasn't prejudiced you. If anything, having it play out as it did on cross-examination in the presence of the jury probably advantaged you. I can't conclude that there's any action that the court should take based upon that omission. Counsel, anything further?
No, Your Honor.
All right, thank you very much. We'll see you tomorrow at 9 a.m.